So June works for a company that makes chocolate pretzels. She's in quality control, and she discovers that the chocolate pretzels are being contaminated with super Ebola. She's really worried. She's so concerned about all the people who are going to die horrible deaths from their super Ebola containing chocolate pretzels. So what does June do? She sends an email to the FDA. Has June engaged in protected activity, assuming the email is about the Super Bowl and the threat to public safety? The answer is technically yes, but I'm not sure that protected activity is going to protect June. The reason being is that we don't know that June did anything to put the company on notice of her protected activity. Sometimes the law requires you to report things to an outside body or entity for you to be protected. The issue then becomes, while what you need to do is report outside, reporting outside doesn't put the company on notice. So June may lose her case at the summary judgment stage because the company is going to put its head in the sand. And even if it did know and retaliated, it can pretend that it didn't. So don't be like June. Don't do that. Immediately after you send the email to the FDA complaining about Super Ebola, also send it to HR and your boss and your boss's boss and anyone else who could plausibly fire you. That way, you're always protected. Let's take another hypothetical. Dana. Dana works at a startup, and the startup is getting ready to go public, and everyone's really excited. And they're so excited, they've started cooking the books. The way they're reporting revenue is all messed up. It's fraud. Now, Dana writes an email to HR and to her boss and her boss's boss, and she complains internally. And she says, "This is super illegal. And if you don't cut it out, I'm reporting into the SEC on Monday." Is that protected activity? Well, under Dodd Frank, it isn't. Now, there are other laws that might protect you in that situation, but they might not. So it's totally crazy, but threatening to report fraud to the SEC may not be protected activity. So, what should Dana have done? She should have reported first and then told her bosses that she reported. That is always, to be safe, the correct order of operations when you're engaging in protected activity. If there's an outside body that you can report it to them first and then tell your bosses. And this actually goes for more standard claims like discrimination or sexual harassment, because if you write an email to HR that's ambiguous, you may be deemed to have not engaged in protected activity. So if you file a charge of discrimination about the sexual harassment or race discrimination and then tell HR about your charge of discrimination, I don't think any court is going to say that the company wasn't on notice that you engaged in protected activity, that your protected activity was ambiguous. So, as a general rule of thumb, I wouldn't try to learn the law or be creative here. If there's an outside body you can report the illegal conduct to, I think the safest course is always to report to the outsider first and then immediately before they have a chance to retaliate and pretend they have no idea what you did, let HR, let the company know, let all the relevant decision makers know that you went outside and that you engaged in protected activity. As always, though, it's better to do this with an attorney. An attorney can coach you through the process. It can make everything simpler. They can help you. They can ghostwrite emails. They can explain situations to you. This is the way to go.